Good afternoon, everybody. We are from Century Maxim International, a legal consultancy firm based out of Dubai. Thank you, everybody, for registering for this webinar. In this webinar, we will share our views on a very important and widely discussed topic in the UAE, which is will formation for expats in the UAE. We'll just wait one more minute before we start on the content. Maybe a few more registrations are to go live, and then we start. We appreciate taking out time on a Saturday for us, giving us time to explain on this important subject. So thank you, friends, for joining the session. We'll start now. With me, I have Ms. Nupur Prasad, a lawyer from the Supreme Court of and High Court in Delhi, India. My name is Farat Ali Khan. I'm a lawyer from India, and I'm providing legal consultancy services in the UAE. We decided to do a webinar for our friends in the UAE, explaining them the importance of will, why will formation is important for expats. As we proceed on this session today, we decided to give a quick background about our firm. So we share the slides with you. So Century Maxim International is a firm registered in the UAE. We provide legal consultancy services. Our practice areas include business integration, compliance management, contract management, corporate governance, financial and capital markets, litigation management, IPR and trademark, private office, which includes will formation and succession planning. In this web session today, we discuss will formation and its importance. This is a team of legal professionals based out of UAE and India, and hopefully soon and upcoming other locations. About us, I manage the firm Century Maxim. The areas that we practice, I've been working on for the past 14 years is corporate and commercial contracts management, due diligence, policies and codes, employment, litigation and dispute management, and of course this topic of today, which is the form. With me is advocate from Delhi, Ms. Nupur Prasad. She practices before the Supreme Court of India and the High Court of Delhi. Nupur has got more than 17 years of experience practicing on civil and family law matters, corporate and commercial matters, labor laws, legal methodology, and other matters. So as we start, we'll explain why will formation is important in the UAE, will formation and its importance. So the first question that we'll try and explain our audience is, what is a will? We then proceed and what assets and properties can be included in a will. What is the procedure for a will formation in the UAE and for Indians and other expats living in the UAE? And what for assets which are located in your home country, whether a will can be formed in the UAE for assets in your home country. So when we say will, so will is basically it's a legal declaration of the intention of the testator. So a person who would want to form a will, he would summarize whatever his declaration would be, that after me, the properties would be distributed as per my will, as per I would want the properties to be distributed to my beneficiaries. In a will document, it is a trustee is appointed. The trustee is the key person responsible to ensure that the properties are distributed to the beneficiaries as per the will of the person who is passed. And the ultimate objective of a will is the beneficiaries enjoy assets after me. So if I have a property, which could be apartment, villa, real estate, land, bank balances, fixed deposits, gratuity, employment benefits, I would form a will outlining my successors, my beneficiaries receiving a share which I would want, which would be as per my will. So that's the main objective of a will. Now, what would a will include? So, key essentials of a will is who is the executor, who is the trustee of the assets. It could be a family member, wife, father, brother. Who would be the beneficiary? It could be family member, wife, children, parents, brother, sister. And in the will document, it has to be clarified how and when the beneficiaries will receive the assets, in what proportions they receive. And if there are any minor children for a person who has passed away, then who would be the guardian of the minor children? So all these things can be outlined, can be declared in a will. So as we proceed on this, on a discussion of these topics, we would be, if there are audience who would want to put up questions, they can, send us questions through the chat room. Subject to availability of time, we'll try and address, try and answer, address as many as we can. So why now in the UAE, this is a very regularly discussed question. Why a will is important in the UAE? Why an expat should consider forming a will in the UAE? Now, see, UAE is a territory, a jurisdiction which is governed by the civil law under the principles of Sharia, and it is recommended that a non-Muslim expat, whether married, unmarried, good health, bad health, or divorced, living alone by himself, uh, should have a will. One simple reason for this is that in the absence of a will, the determination of how the property would be distributed could be a longer process. Say, for example, a person who lives here has passed away, and the family members would want to recover, take control of the assets, whether it is bank balance, whether it is gratuity, whether it is any apartment, property. Now, it is urgent that the family members take control of the same as soon as possible. If it is not, if there is no will, if there is a will, then it fastens the legal process. The court gets a clear understanding. The legal authorities here in UAE get a clear understanding that this person has appointed Mrs., Mr. So and so as a trustee for assets to be distributed to beneficiaries in the following manner. And it is a legally acceptable, legally registered document before an appropriate authority, a court, so it is acceptable. Now, another important reason why a will is required, or is recommended, in fact, recommended is that under the civil law principles of Sharia, other family members are also, the formula of inheritance is extended to other family members, which could include parents, siblings, and other relatives, as the case may be. Now, if there is no will, the authorities would ask, okay, where are the parents? Now, parents could be living in India or wherever, whichever the home country would be. Getting confirmation documents, proof of parents, brothers, etc. Even if the parents would say that, okay, whatever the property is, give it to the wife of my son, or the brother would say that give it to immediate family members of my brother. But getting confirmation, certified documents, NOCs could be a much longer legal process. It could take, because all these documents would require to be attested in the official channel. So, the key point here is that, will in UAE, it helps in fastening the legal process, it helps in deciding on distribution of properties. That's the main objective of will. So not having a will, as I just mentioned, if a will is not formed in by an expat in the UAE, what could be the challenges? What could be the situations, circumstances, issues that could arise? See, whether one has a will, not have a will, the property would ultimately go to the beneficiary. But not having the will would in a nutshell mean that that it is a longer legal process for the family members to obtain custody and enjoy the benefits of the property. Because, as I mentioned here, the provisions of civil law apply. Bank accounts could remain frozen for a longer time, so hence leading to more difficulties to family members. Assets, the courts would want that the assets be distributed to other family members, who could be brother, sister, parents. Now, this would mean that the family members of the person who's passed away, if living in India, they would need to get NOCs, etc. And as we all know, mostly in the UAE, within the expat population, most of us either live by ourselves or with immediate family members. So we don't have brothers and father, mother, parents living with us. So this actually helps us uh, benefits that outlining, explaining the legal authorities here, explaining the court here for a succession certificate that after this person has passed away, these are the beneficiaries. So there is a law in the UAE, and we must thank the government of UAE for making special legal provisions, for expat community living in the UAE, allowing them that they can apply their own country's law when it comes to personal matters. Now, the UAE personal law states that the law will be applicable to non-Muslim unless he elects otherwise. Unless the person has said, no, I would want that law of my country be applied on my personal matters, it would apply, the UAE law would apply, which is a civil law based on the principles of Sharia. And the law of UAE, Article 248 of the federal law clarifies that a will is valid if made by a person having the capacity 18 years and above, and he should be able to donate these properties. So there are provisions of law which support a will in the UAE. In addition to this, there are special provisions for non-Muslims of other countries, allowing them that their personal matters can be governed under their home country law, which is absolutely exceptional and very very supportive for the expat community. So where we can register a will. So in UAE, there are the courts have provisions of getting a will registered. In addition to, and what type of courts do we have? One, we have the regular court, which is the Dubai and the Abu Dhabi court. The Dubai court, there is a public notary section where any person can go, make a document, declare who would be the beneficiaries, how the assets would be distributed, and this document, which we call a will, would be registered before this authority. Similarly, in Abu Dhabi, we have the Abu Dhabi Judicial Department, which is part of the Abu Dhabi courts. But one important point I would like to mention to the audience here is that Arabic is a mandatory language for will documents which are registered in the mainland of Europe. Right? And under the laws, as explained earlier, the courts of Dubai and Abu Dhabi, they allow non-Muslim expats from any emirate to form and register a will, covering assets all across the UAE. Apart from the regular courts, we have a special zone here, which is called the DIFC, Dubai International Financial City, which has its own set of laws, rules, and it has been constituted under a special law, which has a special court also for other commercial matters. However, this court has also been approved to register will for assets, companies, properties, which an individual or a person may have here in UAE. One benefit with DIFC is that English is the main language. So these are the two places where will can be registered in. Right? So if there are any questions, you can please sending us. You may send us messages in the chat room. Our team would we will try and answer whatever we can, but obviously subject to the availability of time for our. Now, what may be included in a will? So, Article 262, 264. So, one thing I would like to mention here, we did not want to put too many legal terms, provisions of law, just to make it simple for our audience to understand. Explain in easy language. So, just explaining this, so the law of will allows that a will may be general will or a specific. So a general will would mean that all assets will be covered, whether it is bank account, whether it is gratuity, whether it is employment benefits, whether it is real estate investments, shares in a company, auto vehicle, whatever it is, it could be included in that. And custody, guardian of children after the person is passed. Specific will could be, a particular bank account, a particular property, or shares in a particular company, or whatever limited assets a person would want to allocate to a set of individual or beneficiaries. So a general will, as I explained, will include all the assets of the testator, present and future. Specific will may be limited to particular properties. In DIFC, which is a different zone of the regular Dubai and Abu Dhabi courts, uh, there are classifications. One may have a general and a full will. In addition, there are will formats, provisions acceptable where a person would say that after me, if my children are minor, the custody would go to my sister or my wife, or my father or my sister, whatever the case may be. Similarly, a will can be specific to property. That if I have an apartment, a villa, a real estate investment in UAE, these investments would go to this particular person. So there are classifications for each and everything: guardianship, property, business owners, financial assets, and companies located in the people. Shares in the company which is located in the people. So we have another topic for our audience here, which is will for assets in home country. How would this work? I would request Ms. Nupur Prasad to take over from here and explain how would this work for the audience if there are somebody who would be interested in getting a will formed for assets located in home country. I apologize to the attendees. We are for a reference for discussion. We are kind of covering only India today because it's a limited duration webinar. So, Ms. Nupur, please.
Thank you, Farad. It was a very informative session. Hi, everybody, all my friends from India and the UAE. So I think I'll start my session. I'll start my topic with a simple saying that when there is a will, there is a way. I'll repeat this for the sake of clarity or interpretation, that where there is a will, there is a way. So what I mean to say over here is, in absence of will, what can actually go wrong? Having said so, we don't say that your properties don't get to be given to the inheritors or the legal heirs that you have. But what we are trying to say is that in absence of a will, there might be difficult ways of dealing with it, which is probably a little more difficult and a non-comfortable area for a person who's left a lot of asset or a property which needs to be bequeathed to its legal heirs. So we start with what is a will, which is already explained by Farad. So I'll just go down in a smaller detail. It's no different in India. So in India too, a will is actually a document that names each individual and actually divides the amount of property and the assets which an individual will have after the death of a person who this property belongs to. So when I say property belongs to, a will has to be actually given for the property which belongs to the person who is wanting to have a will. So just to give us a very small example, let's suppose in between a husband and a wife. Now there is a property which is jointly owned by a husband and a wife. What we do is, so a husband is actually only be able to make a will for the property which he owns. he cannot make a will for a property which he does not own. So where I say that for properties which belong to me, this is what I mean, that I cannot bequeath or I cannot actually make a will for certain assets or properties, both movable and immovable, if they do not belong to me. Legally, do not belong to me. So that's where we call that what a will is. It's same all across. What we have a will, how we define a will in the UAE is how we define it in India. There's no difference. Now in India, the only thing that we have is that there are things where we say that how actually is a will made. So how do I make a will? In everywhere, what we do is that we just need to make a will on a piece of paper. It is for a certain documentation, we do require stamp paper, or we do require certain agreements to be on stamp paper. But for a will, we can actually make it on a plain piece of paper. So it's always better to have a will, because it does not really require you to stamp it or have a stamp duty paid on it. That's one part of it. The other part of it is that a will is actually required to be signed by the person who's making it. So to say, we call as a testator. A testator is actually a person who's actually to whom the property belongs and he's making a will, and it requires a two-witness attestation. That's what we mean by how we make a will. Now here I have a law on will formation in India, which in the UAE, which means that will means the legal declaration of intention of a testator with respect to his property which he desires to be carried into effect after his death. This is defined as, so to say, in Indian Succession Act, like it is defined anywhere else. Now there is a term called probate, which you need to take in, which is actually in India. It is not mandatory in most of the states, and that is actually given by the competent court of law. Now, what is a probate is something that I would like to explain. It's basically a validation by the court of a competent jurisdiction. That is all it is, but it is actually not mandatory in India. Now, if I were to talk about, I would just go back to the previous slide and talk about registration of a will. Now in India, there is, it's not important, it's not very actually mandatory for registration of a will. But the question that arises in your mind is that then why should I register a will? So two things which I would like to place here, why do you need to register a will is, first, you actually register a will because there might be a situation where you might not want to give certain properties to certain of your legal heirs, or maybe somebody who might feel that I am not being getting this property or that property, which is why it is said that it's always better to have a registration done. So just to give you an example, let's suppose I want to bequeath my property, but I want to exclude one of my sons or one of my daughters or anybody from the will. Now, having said so, because she is a legal heir or he or she is a legal heir, there might be a situation that they might create a dispute after my death. So therefore, I go and have it registered to give it a legal value or a legal implication or a legal validity is what I would say. The other thing that why a registration I would say is important is that there are certain beneficiaries who might have a dispute, who might create a dispute that I should this, I should have got that. Therefore, it is always good that we register a will. Now the question arises, where do I register a will? So in India, normally we register a will with before the registrar or the sub-registrar of the jurisdiction of the area that your property is or where you belong. So that's how we do. Now I'll just move on to the next slide. And we have already spoken about probate here. We have spoken about what a will actually is. Now, the question that comes to my mind is whether who can make a will, which Farhat has already taken us through. But in India also, so a person who's actually not a minor, or probably in simple language, so to say, a person who's attained the age of 18 can make a will, and a person who's of sound mind. So if just to give you an example, a deaf, dumb, or a blind person can also make a will so long as he's of sound mind. So we come back to registration. What do we really require when we register a will in India? So what we generally require is for people who are non-resident, who are or maybe domiciled in India, staying abroad. What we need is the original signed copy of the will. We need the personal address and the ID documentation, and what we need is the documents signed and registered before a sub-registrar. That's what we generally need in a will. Now, there is a question which also might come to your mind that, if I don't register, whether it is really going to take any effect on me. So, well, I would say I've already explained that a registration is not mandatory, but if you register, it gives you a legal sanctity. And coming back to why you should make a will or how you should make a will, see, the only situation which arises is that you might have a lot of assets, but there could be disputes. So if you don't make a will and properly have it documented, in that case, the only way your property is going to be given is through an interstate succession, which is carried forward by the Indian Succession Act in India. So having to be in India, the properties in India, even if you're sitting in the UAE, you can make a will, and it is always better to have a will. Now, how do we obtain probate on the will is something I'll just take you through very quickly. We say that while most states in India do not actually make a probation of a will, which is mandatory, but will probation maybe for the property located in India, whether it is made in India or outside of India. A probate is issued with reference to Section 57 and 213 of the Indian Succession Act, which I've already detailed. So these are under these sections we actually have this probate given, and the probates are granted to the executor or executors by the High Court with a copy of the will attached. Then one can actually apply for a probate after 7 days of the death of the testator. The testator, again, the person being whose will is actually made or who is actually wanting to divide his assets. Now, the major question that arises with all of us is, what will a will contain? So it's no different than what Farad had taken us through. It also, in India, also you have these things that you can include in a will, and it is always good, suggested that everything that is under your name should be actually kept a part of the will. So we have movable or immovable properties of any kind, whether it is or probably you own them completely, or there is something that you have booked and is in your name, but you've still not got a possession. That also is something that you can put a part of in the will. Then you have your bank accounts, your lockers, your fixed deposits, or your any other things that you have. That is a part of that, can be made a part of the will. Your jewelry, the real estate, as I said, that real estate might just include both your immovable properties, and it will also include the properties for which maybe you have, let's suppose I were to give an example that I had applied for a house or a property somewhere, but I still had 2 or 3 years for it to get to get a possession of it. That also, if it belongs to me, it is in my name, then I would be able to put that under the will. And I can also put my shares, which I may have of a company or any other thing as part of my will. And any and all assets which are there in India can actually be made part of this will, which you can make sitting in the UAE. You need not come to India for that. That's a very big advantage that you have. I would request Farah to take us forward from here now.
Thank you, Nupur. Very, very well explained. So I will just explain what CMI would assist with. One, we've just got few questions. I mean, we've got a lot of questions, but then we'll be able to answer few. Can't because of the availability of time. The time we promised, we're already exceeding 30 minutes, but no worries. Uh, so, so what do we do? I mean, CMI we explain where is the document which requires a lot of thought processes to be applied. A person would want to think who should be the beneficiary, who would be the executor, how the assets would be distributed, and how would this will be enforced. So we discuss and advise our clients on a proper succession planning, how this will document will be framed so that the beneficiaries get the proper allocation of shares. Drafting of will is the major area that we work on. We explain our clients the legal aspects of a will, which we've just spoken rightly in this presentation, that what are the legal provisions of UAE, what are the legal provisions of India, and what could be the legal provisions of different home countries that a person may come with. We assist our clients in the on the registration formation of a will before the appropriate authority, whether it is here at the regular Dubai court or at the consulate embassy of India or respective country. In India, as most of the states do not require, but as lawyers, we think that it could be important if a will is probated so that the legal validation is issued. We assist clients in getting the will probated so that a dispute could be avoided at a later stage if it may arise, or if somebody in the family would want a contest on a will with respect to certain things. Very important when we have a client onboarded, a will could be in a number of copies. One copy may be preserved by the person who's making the will. He may give it to his immediate family member, wife, father, mother. Apart from this, we also provide custody of will documents. We provide a safe storage service also to our clients, and just for the sake in case there's any requirement of the same, submit as an. So this is what we do, and we look forward to assist. I would just, I've picked up 3, 4 questions which I would answer, which have come to me. I'm sorry, I would not be able to answer questions which require a lot, an explanation, citing the provisions of law. Specific questions. So one question is from a friend here, Abhijit, who's asking if the bank account of property is in the joint name. With this spouse, will the assets automatically become of spouse? No, that could not be the case in UAE, because UAE does not, it does not recognize joint ownership of property, particularly in bank accounts. Like in India, we have this concept of, opening a bank account as an either a survivor, which is not the case in UAE. So even if it is a joint account, it would be immediately blocked. Same second question from Abhijit. So, can the beneficiary also be an executor? Yes. So if I am making a will, I would make my wife the executor, and I would think that okay, my wife would be beneficiary to this percentage, my son would be beneficiary to this percentage, my daughter would be beneficiary to this percentage. So it could be yes. There's another question from Samir. He's asking whether DIFC will cover all the assets. So yes, now DIFC under a new regulation, a will formed in DIFC covers all the assets across all emirates of UAE. I will just take one more question. Is where is it better to have the will registered, DIFC or local courts? It's the same. I mean, it's more or less the same. So, but this is a very very subjective. Nirmal, and I'll send you a detailed note, or we can have a separate discussion. Explaining it's all about a matter of preference or convenience, how it's used. So this is it on the session. As we explained, discussed that will formation is important in UAE for expats. We really appreciate, thank the government of UAE for having made provisions in the law applicable in UAE, allowing expats to elect laws of their home country, which would not be a position in most of the jurisdictions. So I think we've covered most of the important topics. Anything you would want to add to this, Mithra?
No, I think you've covered many other things, but we have a lot of questions. If we can address them individually, we'll do that.
Yes. So please.
Quite interesting, I see.
Yeah. So please, if there's anything, reach out to us using this email ID, which is info@centurymaxim.com. You can connect to us through our website. One thing I would like to clarify here that this presentation, is kind of a guidance, is kind of a, our view on why it is important to have a will farm in the UAE. Please do not take this as any kind of a legal assurance or guarantee that if a will is formed, then whatever is mentioned in the will, would be passed on to the beneficiaries. Because will is a legal document, and legal documents are always subject to a test. Could always be a subject to a test before a court, right? So thank you everyone. Thank you Nupur. Thank you team Gentry, Maxim, and others who assisted us in getting this webinar conducted. I really appreciate. I mean, I've seen registrations from India, from UAE, of course, and also from UK. It was early for UK, attendees on a Saturday of that. So thank you. Appreciate everyone for joining the session. Please get in touch in case there's any requirement. If I've not been able to answer your question, you can simply put it on an email, send it to us at info, and we get back. You may put your mobile number, and then we'll call you. We'll So thank you everyone, and we look forward to have more sessions of these types, sessions of hopefully next month on immigration laws, and we'll be getting lawyers from UK to advise us what are the provisions of and all related to immigration in UK, how businesses could be moved from one jurisdiction to another. So here we end. Thank you everyone, and
thank you everyone.